Welcome everyone. My name is Professor Charles Szymanski from the University of Białystok Faculty of Law, and in this lecture I'll be giving an introduction to the U.S. legal system. The American legal system is a common law system. In this system, in which it shares with many other colonies of the old British Empire, it's a system based on precedent. What does that mean? It essentially means that judges and a judge makes law. They decide the case and they reach a decision, and this decision should be followed if it's made by a higher court, by lower courts in the future. So a judge in the future at a lower court may have a different opinion about what a higher court has decided in the past, but they have no choice. In most cases it's binding precedent, and they have to follow what the higher court has said. And in this way the law develops over time through judges interpreting the law and seeing if they're bound by precedent, by cases decided earlier, or if it's a new case that warrants a different decision. The legislature has a role in a common law system. Originally it was judges that were driving everything, they were making the law. But the legislature in the United States does have a possibility to correct the common law. So if judges are making bad decisions or not popular decisions and times have changed, the legislature, in this case Congress, but it could be the state legislatures, can change the legal system. An example was the employment at will system in the United States, where under the common law, under this judge-made law, you could fire anybody for no reason or any reason. But over time, the legislature realized that that was unfair, and especially in the areas of racial and sexual discrimination, this principle, this common law principle, had to be corrected, and the legislature is free to do that. There are some advantages to a common law system like the American system. It's said that a common law system can react more quickly and better to new conditions. And so we see with artificial intelligence, with the gig economy, with new technology in general, sometimes it's difficult for legislatures and lawmakers to catch up. The technology is advancing too fast. One advantage of the U.S. system, which is based on the common law, is that judges are free to adapt. They have some flexibility. And when they have a new situation that hasn't arisen before, they could make precedent, they can make their own decisions. They don't necessarily have to wait for the legislature. The legislature may later change the law, but the judges are free and have a lot of independence to react to it. And this is said that this has helped the American economy because the common law system is a bit more flexible than systems that require the legislature to make most changes in the law. The United States is a federal system, and therefore there are federal courts and there are state courts. There are 50 states in the United States. They have their own, each has their own Supreme Court, their trial courts, and in most cases a court of appeal, as does the federal government. Usually they don't interact with one another. There are cases in which they do and special rules apply, but often they have their own spheres. So state law generally deals with contracts, with torts. These are personal injury type claims, family issues, and many criminal matters. Federal law deals with things that are connected to interstate commerce, commerce between the states, also with intellectual property, and many aspects of labor law are also exclusively in the federal domain. So each sphere has its own types of law that they deal with, and they operate independently. But in the federal system in the United States, ultimately there is a federal constitution, and all states are subject to that. So states do have a wide degree of autonomy, but in the end they have to answer to the federal constitution, and their laws have to be constitutional. And we see on the map that these are various districts and areas and regions that are consolidated for purposes of courts of appeal at the federal level. And just to give one example, California we see in blue, the Ninth Circuit Court of Appeals. This is a court of appeal in the federal system. It would cover all appeals from the western United States. So it's done regionally, and then ultimately it would go to the Supreme Court of the United States. The Supreme Court does not have to take a case. They only take the most interesting and important cases. But that reflects kind of the regional breakdown of the Court of Appeals system. In the U.S. Legal system and in the federal system and the state systems, there is basically the same types of civil procedures, same basic principles. A case begins with a complaint, and then it's responded to by an answer. Was there a violation of the law? And by answering, a party would deny it, as usual. The discovery process enables the parties to get additional information about the case by taking depositions, by asking questions, by getting documents. The discovery process takes up quite a bit of time in the American system, and parties could see the relative merits of their case and decide whether to settle it or to go forward. I just want to talk briefly about some unique characteristics of the American legal system. One would be about punitive damages in the U.S. and torts. And torts, again, is basically injuries that you've suffered because of someone's negligence, they've made mistakes, or intentionally they've harmed you. And in those types of cases, it's possible in the American system that there are punitive damages. And punitive damages are to punish the person or entity or corporation that caused you harm. And it could be extra millions of dollars. The idea is to deter corporations and people from doing the same conduct again. It's somewhat unique in the American system, but the idea is it shapes behavior going forward. Another particular aspect of the U.S. legal system is class actions. Essentially, in a class action, similar cases are bound together. So for those of us, and I think everybody does, if you have a mobile phone account, an internet account, perhaps your provider has overcharged you 10 cents or 10 grosze. And you're not going to sue anybody for that, you're not going to go forward. But with the option of a class action, like in the American system, there might be 10 million customers that were overcharged 10 cents or $1. If you put all those cases together, then it's a serious case, and hopefully the company will listen to you and resolve the matter before it goes to court. It essentially equalizes small claims and small parties with a bigger party, and it's been quite effective in the United States. In the U.S., there's a relatively, we would say in some ways, a basic constitutional system. The American system is based on an old constitution, which has been amended and changed a bit over the years, but the basic document is the same as it was hundreds of years ago. And the Constitution breaks down, as we talked about, what responsibilities go to the federal government and what responsibilities go to the states. It also breaks down the three branches of government: the executive branch, the presidency, the legislative branch, Congress, and also the courts. In theory, these should be all equal. Article 1 deals with the Congress, the powers of the Congress, Article 2 that of the President, and Article 3 that of the judiciary. The greatest power of Congress is to pass legislation in certain areas listed in Article 1. The power to legislate about interstate commerce is the broadest. Almost everything affects commerce between the states, so in that sense Congress has wide powers. The President has powers about national security, is the Commander-in-Chief of the Armed Forces, and also appoints members of the Supreme Court for life with the advice and consent of the Senate. The judiciary, as we explained in common law systems, has a great deal of power. They have the power of judicial review. They could say anything the President or the Congress has done is unconstitutional. That gives them a great deal of power, and they're appointed for life. In theory, again, these should be all relatively equal. Slightly after the U.S. Constitution came into effect hundreds of years ago, there was amendments to the Constitution giving Americans individual rights. Probably the most important of these, and the most well-known internationally, is freedom of speech and assembly, where you could basically say anything you want, especially about public figures. It's different than the European system. And so we could have very harsh criticisms, even almost defamatory criticisms of a public figure like the president. But the idea is, let's not restrict it. The answer to free speech that's maybe wrong is more speech to correct it. So in the American system, just to give one other quick example about how far freedom of speech goes, free speech covers your right to burn an American flag. And there was a famous case dealing with that where veterans were extremely upset by that. They said it's a symbol of America, but a protester wanted to make a statement, and that action was free speech protected by the American Constitution. There also is in the U.S. legal system some special rules about ethics and legal education. I just want to highlight one thing connected with free speech, and which is unusual in other parts of the world, that lawyers often can advertise as part of their rights of free speech. And so in many European legal systems, lawyers cannot advertise. It's a very prestigious profession. But in the U.S., you can and do see some rather unusual advertisements, and that's connected to the right of free speech. That's an overview of the American legal system. I hope that provided an interesting and a discussion about these key aspects. I hope it was helpful, and I invite you to the next series of lectures. Thank you.